say this in a way that's most understandable. I think there's an expression, we're at the 11th hour. This is probably even beyond that. We're probably at about 11:59 here. We're about to close all of the evidence in your case, which would be submitted to me with the jury's recommendation, whether you should receive the death penalty or life in prison. Counsel has already done his job. They've already completed their work on the case. Really, at this point, all that's left for them to do is argue to me. So I don't believe there's really any purpose in that at this time. Even if I were to grant your request, there's nothing left for counsel to do at this time other than to make argument to me, which quite frankly could be persuasive, but given the judge's function, where we are, as I mentioned, 11:59 metaphorically, there's really not much purpose in that. So from counsel, since it does affect counsel, does counsel agree with my observation on that particular point? I'm going to inquire Mr. Soto-Escalera whether he wants to speak about the decision I have to make and give me input in that regard, because he has the right to do that. But that's separate and apart from what's being said now. Does counsel for the defense agree with my observation as far as, if this is a request to discharge counsel, where
Absolutely, Judge. And that
the horse is out of the barn at 11:59 p.m., I suppose would be the metaphorical.
correct. And as I explained to my client, I am not qualified to be on the case by myself because I'm only second share qualified. So Mr. Burns has to remain on the case to the duration.
Right, and just for the record, I haven't heard the arguments yet, but there's been a substantial amount of mitigation put before me, both at the trial and additionally here today, that I have to consider and digest. And does not seem to me that there's any reason for me to discharge counsel at this time. More importantly, before you brought that up, Mr. Soto-Escalera, you do have the right to make a statement at this time, either under oath or otherwise, that I would consider in making my determination in this sentencing proceeding. You understand you have that right to do that. And I was assuming that you were going to do that. I'm not saying whether you should or not. That's between you and your counsel. But I want to make sure that by me dismissing your conflict of interest issue, you don't take that as me dismissing your ability to make such a statement. Do you wish to make such a statement, or do you wish to talk to your counsel about whether you wish to do that at this time?
The only reason why I brought it up, Your Honor, is because something has surfaced with a witness and it was recorded in audio. This is why I'm requesting that I would have him removed. But if I can't remove him, I would like you to see what I'm speaking about so you can understand what I'm trying to say, if you have the time, Your Honor.
With regard to that, that would be a decision in this very important context for your attorneys to make, whether to submit that issue to me as far as potential mitigation. And as I'm required to do, I would defer to their professional decision in that regard.
Enough, Judge. I'm going to lay it all out on the record, okay? I think Mr. Soto-Escalera is hurting his situation. He's proceeding in ignorance on the advice of ignorant people. What he is referring to is a Zoom recorded deposition, the first such deposition I ever did in my life. We had witnessed Lucinda Cook. This was done, I think, on the Tuesday when there was a court holiday, when we were in the midst of trial or jury selection. I'm not sure exactly where we were yet. And before Ms. Cook joined, there was a recording with chit-chat between me and Mr. Richardson about witnesses in the case, about the state of the case, about why I was calling witnesses and not calling witnesses, and complaining about somebody who had Ms. Minton's credit card and was going over the limits, and chit-chatting as counsel do between themselves waiting for a witness. And I don't think people understand the context of how attorneys talk to each other. I think that the witnesses who overheard this, Ms. Lucinda Cook and whoever else she communicated with, think that because this is a capital murder case, me and Mr. Richardson should be like this with our hands around each other's throats every moment. And we were not that way. We were chatting as counsel do in a case. And in a capital case especially, do counsel and adversaries have to communicate frequently and exhaustively to get the thing from start to finish done. That's all that it was. There is nothing in there that was inimical to Mr. Jose Soto-Escalera's defense, and I defy him or anyone else to point to any action or anything that I did or said at any point in the preparation of this case, or in the trial, or in the penalty phase that was contrary to his interest. It's nonsense and bullcrap, and that's what he's on about, Judge. So he can feel however he wants. He's an idiot. On this issue, at least.
In that regard, for Mr. Soto-Escalera's benefit, the people who are here observing this proceeding, regardless of the court's sentencing decision, whether I impose a life sentence or a death sentence, there are appeals that take place directly, and then indirect appeals which relate to assistance of counsel, whether the defendant received proper assistance of counsel. That's for a different day. I could see this coming up perhaps in that scenario on the merits to be figured out at that time as appropriate, which goes back to what I said before. The evidence is in, mitigation has been placed before me, so we're at that stage where I'm to consider that. Put differently, if Mr. Soto-Escalera feels that Mr. Burns did not properly litigate his case for whatever reason, will be a proceeding in that regard. But to be fair to Mr. Burns' respected counsel before the court, usually what has to be shown, or what would have to be shown, is something of substance, not just some idle remark we see from criminal defendants all the time, like, my attorney is working for the state, because look, they're smiling at each other and they're acting as professionals and not constantly cursing and berating each other and putting each other down. That's not the expectation of the court. In fact, we foster the opposite as professionals, that they get along, because once this case is over, they'll be on to a next case, and so will I. And so as professionals, they have to work with each other. But more importantly, as I mentioned at the outset, that is for another day. I'm directly focused on the extremely consequential and important decision I have to make, which goes back to whether Mr. Soto-Escalera wants to make a statement regarding himself, the case, for me to consider. He does not have to, and it's not going to affect him negatively if he doesn't, but he has that right to do that. So there again, we broached a different subject. I don't want him to think that I'm not going to listen to that, should he wish to listen to make that statement. On the other hand, I'm not sure he has an intent to do that anyway. He just wanted to broach this subject.
Judge, I think he
Okay.
said his piece and he has nothing
Okay.
to say at this
All
time.
right, so it's not the first time I've had to tell the defendant or someone else, that's for another day. There is a right to have a motion for post-conviction relief with regard to your Sixth Amendment right to counsel. That's for another day, really, regardless of my decision here. So other than that, that concludes the Spencer hearing evidence from the defense. Any evidence from the state before argument?
No evidence, sir.
All right, so let's start off with the argument of the state. If you wish to make a summary argument, but you don't have to. I mean, obviously, I'm familiar with my role here. I want to dissuade you from that, but you do both have the right to make argument to influence me in the way I evaluate the evidence,
Sure.
the way the aggravation and mitigation.
Yes, sir. I would just say that based on the extensive evidence that was adduced in the trial and the penalty phase, based on the findings, the aggravated factor findings of the jury, as well as the verdicts of the jury as a whole, the state requests that the court impose 2 death sentences in this case on both counts. Thank you.
Thank you. And the defense, Mr. Burns.
Yes, I do have a few comments to make, Judge, in the nature of argument, some of them addressing aggravators and some just in general. One of the things that needs to be considered and proved is that there was heightened premeditation in this case. I think certainly there was evidence that this case was planned and thought about at least for some days before the actual killing occurred. I don't know how extensive or how important the court would consider the testimony of the witness who indicated that Jose was interested in ghost guns, I think a couple of weeks before the killing. I don't know whether that manifests as an expression of an intent to do anything wrong. This was not a shooting or a gun crime. It did not arouse in the witness's mind at the time that there was anything nefarious going on. He thought that Jose might have been building a gun for sale. And so what we have here, the evidence in the case was that this was a pregnancy of many months' duration that Jose objected to from the start, and yet there was no evidence of any kind of intent to do anything wrong until only a few days before the actual event. And so I would ask the court to consider that. On this next issue, again, I don't like to tread here, but these are just unsavory matters to begin with. Regarding the aggravator of child under 12, I certainly do not dispute that that aggravator is correctly found. I do offer for the court's consideration that the manifestation of that aggravator in this case is as mild as could be. I don't want to state it any more bluntly than that, but what we lost here and what we mourn here in Josiah, we lose and mourn speculatively. There's no personality that has been evinced. And so I think that although that aggravator is properly found, it could be even more horrible. We have testimony from Raul Benasco relative to the court imposing a life sentence without the possibility of parole, which is what I'm asking for in regards to each victim. That Jose's been fined while he's been incarcerated for many years in a county jail, which is not designed for long-term incarceration. He would be a good prisoner. He has skills to offer. They work them hard in prison. Jose has skills to offer. I also want to ask the court to consider that the nature of persons who ought to be executed should be such that Jose doesn't really fit the category. He has no prior criminal history whatsoever. This is a dramatic departure from nothing to a very horrible crime, but it is a crime of personal circumstances. It is not a crime of randomness. It is not a crime against strangers. It is not a crime where Jose indicates that he is some kind of danger to the community at large. It is a very particularized type of crime, again, wildly at odds with his nature that we heard from his family and that we heard from Dr. Schwartz, and that is evidenced in his lack of a criminal record, which I think is really quite astounding. And finally, I think I would be remiss if I did not remind the court that although the recommendation is for death, it was as close a call as could be possible, and I would ask the court to consider that also in leaning towards life without possibility of parole for both counts. Thank you.
Thank you. Any